much, His Excellency, for the introduction. I thank the organizers of this conference for inviting me, and I thank all of you for attending my presentation. I was so interested in this conference that I decided to fly 24 hours from Adelaide, Australia, to come here. 24 hours in the plane, not in my way. And not to take 2 hours flight to go and watch rugby in New Zealand. Also, don't be offended if you are English or Pakistani, that I would have come to this conference even if Cricket World Cup was held in Adelaide. Now, the title of my presentation is Sharia in Modern Democratic Nation States. As you can see the title, and as I can see from presentation by Dr. Marbo and the questions and discussions, all of those words are very sensitive. Sharia, modern, democratic, nation state, international law. So I owe you a thank that you made things easier for me. Now, if I was presenting before you, I would have made things easier for you. So I would be very careful to explain things when I use them, and I think I do that. I have studied law, I've practiced law in an Islamic or Muslim country in Australia. I've taught Islamic law, so I know I have to be very careful about legal matters and what I do and what I said. Last night in my hotel in London, the TV didn't work. I asked the hotel people to come and fix it. A nice person came in my room, learning from what happened to Dominic Strauss-Kahn. I left the room, standing outside the room. The person fixed the TV and went out. So I know how to present my presentation. Now, in that line, let me explain that I am not going to make conclusions, not because I'm afraid of questions or things, because there is no conclusions really to make. I just would like to acknowledge and raise a number of important issues. Now, what I'm going to do, let me look at my introduction. Now, citizenship and nationality, briefly I will refer it in modern international law and modern legal systems. Then Sharia and citizenship. Then I will explain to you what is, in my view, or different, what is Sharia, according to technical Islamic law. And then look at those concepts like citizenship and nationality in Sharia, how it was developed, and then come to the issue of Muslim citizenship and Sharia, or the issue of Sharia law or Islamic law or practice of Islamic law, practice of Islam, practice of Sharia, practice of Islamic jurisprudence, fiqh, rituals, and other aspects of Sharia in a modern nation state, whether it is Australia and United Kingdom, which are non-Islamic countries, or whether in a Muslim state, which I mean a country where the majority of people are Muslims. Now, to do that, I will explain terminology. Again, it's in my paper. It's not explained because I don't want to get some responses from the audience. It's just because to present my paper, I have to make clear a number of technical, legal, Islamic terms in English and its original language, that's what I'm going to use. I then go to those things which you can see here in my slides. And I will be using PowerPoints, and I tell you that a research in Department of Education in University of Monash in Australia, which is the biggest university recently, proved that using PowerPoints in a seminar or a lecture or presentation significantly reduce the scholarly content of a lecture. I do it because of popular demand and also because I briefly use it for some reasons. But remember that if the scholarly content of my presentation is low, exactly. Okay, modern nation state. I'm not going to give a lecture or discuss this issue in details, but I have put a few things that how the modern nation state was developed. It goes back to Middle Ages. The idea in Europe, 17th century, 19th century, the League of Nations, up to United Nations. As you can see in Europe, the concept was Respublica Christiana, which is very similar to the concept of, for example, Islamic Ummah. The difference is that this concept was developed after the concept of Ummah developed in Islamic history. I also should acknowledge, and many of you know, particularly if you are English, that common law in 1066, before 1066, common law legal system did not exist. We had only Anglo-Saxon customs. By 11th century, Islamic law was well developed, almost similar to what it is now, with some more developments after that. Now, then we got developments in Europe, mid-17th century, 19th century, the League of Nations and United Nations, and now we have obviously nation states, independent, sovereign nation states, acknowledged in international law by United Nations. United Nations has got 195 members, and obviously they all have accepted the concept, and out of that 195 states, almost 1/3 are countries with majority Muslim population, Muslim states, 55 or so. Now, what is nationality and citizenship? Because I'm going to then discuss the concept of Sharia in nation states. I have here a quote from an International Court of Justice, 1995, which is not a very old case, about the concept of citizenship or nationality, which means the same thing except nationality is more used in international law, whereas citizenship is used in national law. And this is, as you can read, the definition of nationality. Nationality or citizenship is a legal bond having as its basis a social fact of attachment, a genuine connection of existence, and so on, reciprocal rights and duties. This is the point which I would like to emphasize, is that nationality, being a national or citizen of a state, that could be, for example, state of Turkey and Saudi Arabia, both with 99% Muslim population, or could be national of a country like, for example, United Kingdom or France, where the majority are not Muslims. In those countries, obviously, in every country, citizenship gives some rights and obligations to individuals. So have this definition here. I may come back to this later. Now, Sharia and citizenship, or Islamic law and citizenship, I would like to briefly tell you about nature of Sharia and then go through my discussions. Before I get to Sharia, let me define a number of words according to what I think are appropriate definition of those words. Islam. Now, everyone knows what does that mean. But it is a word which has got different meanings to different people, to different countries in different times. However, what I like for purpose of my paper, I think Islam can be classified in many ways. Two ways which I like is that one is to classify Islam as scriptural Islam, or Islam which is based on scripture. You've got Islam, Christianity, Judaism, and you refer to their basic principles which is in a book in Islam, in the Quran, and probably we can add to that hadith or sayings of Prophet as well. Then that's one definition of Islam. Then we got also, let me use a bit of Arabic word, Islam al-fiqhi, or Islam, jurisprudential Islam, which is then fiqh. That's not the same as Sharia, is not like Islamic law, and it's not Islam. And it's not jurisprudence. I use jurisprudence because it's translated to English as jurisprudence, fiqh. And fiqh means understanding of sources of Islam, that means scripture, hadith, qiyas, other sources, understanding by Muslim scholars, not ordinary Muslims, who they developed Islamic jurisprudence or fiqh in last 15 centuries. Now, I can go into history and discuss it in details, but I won't. But that's the definition of fiqh. So you may look at, when you say Islam, what do you mean? A scriptural Islam or jurisprudence Islam? Then we have also historical Islam, which means civilization of Islam. That includes everything. Islam, which was developed in the Arabian Peninsula, then it expanded in the Middle East into Europe, India, and it has 15 centuries of civilization. We can also divide Islam in Sharia-based Islam, mystical Islam, philosophical Islam, and theological Islam. Each area you can, when you say Islam, what do you mean? Do you mean Sharia-based Islam that is very based on Sharia? Now, then it comes to the question, what is Sharia? I should explain it because it's title of my presentation. What is Sharia? In English, it's translated to Islamic law. Now, Sharia can be broader than Islamic law as translated in English, can be narrower. Now, generally, if you look at any book of Islamic jurisprudence, al-fiqh, Sunni, Shia, modern, traditional, from after those developments of schools of Islamic law, 4 schools of Sunni jurisprudence plus 1 or 2 or 3 or more Shia schools up to now, if you go and find definition of Sharia, every standard text tells you what is Sharia. Of course, the meaning, the Arabic word Sharia means a river. But it says Sharia includes beliefs or aqaid, rituals, ibadat, transactions. That means, I explain to you if you want, everything, Islamic law, plus uqubats, which is punishments, which again means Islamic law. Therefore, as you can see, Sharia in original sources in Arabic, Persian, Turkish, other languages in Islam, means more than technically Islamic law. Is ritual, its transactions and punishments is Islamic law, so to speak. So translating Sharia to Islamic law or Islamic law to Sharia is not exactly correct, but we do it, and I'm do it as well. Now, Okay, now then we go to nature of Sharia. Now, from now on, when I use Sharia, I mean Islamic law. Now, this system of law is slightly or fundamentally, up to you what you like, is different from other legal systems in the modern world. Because in Sharia or Islamic law, the relationship between law and religion is unique. Now, you can then have different interpretations and different approaches in relation to law and religion in Islam. Generally, if you open English textbooks, particularly written by non-Muslim background people, you see that they say, okay, in Islam, religion and law are the same. Now, this could be right, but may not be technically, legally, exactly true, because there are there is no doubt that basics, principles, general principles, or even every principles of Islamic law should be, or may be, based on religion of Islam. But it may be more than that. Some aspects of law in Islam is expanded in areas which is not exactly Islamic law, but it may not be inconsistent with Islamic law as well. Now, I would to explain this, that under religion of Islam, or under Islamic jurisprudence, or Sharia of Islam, all conducts of human being are divided in 5 categories, and that covers every conduct, including conducts which are subject to law. Now, what they are, I'm sure at least those of you with Muslim background, you know that in Islam every conduct can be wajib or compulsory, mandatory, you have to do it, can be prohibited or haram, which means you shouldn't do it, it's prohibited. Then we got 3 other categories, which 2 are mustahab or mandu, or which means recommended to do it, disliked not to do it, and the 5th category is mubah or indifference. Now, if you look at that 5 categories, then 2 of them are subject of law out of 5 categories, okay? That is wajib, mandatory, you have to do it. If you don't do it, technically speaking, under Islamic law, you breaking law, and you can be punished, and there are sanctions. That includes rituals, okay? If rituals are wajib or mandatory. Now, this is very technical to go into details, but I can give you an examples that in Saudi Arabia, in Malaysia, in Iran, in Brunel, Dar es Salaam, for example, if people even fail some rituals, there are sanctions for that. Now, then we have prohibited. Anything that is prohibited in Islam is also sanctions, one way or another, by Sharia. Now, okay, so that, and those areas are clear, prohibited by the Quran or by the Sunnah or by interpretation from those sources by Islamic jurisprudence or fiqh. Now, how about everything else? In the modern world, or even before that, majority of conducts of human beings nowadays, whether in a Muslim country like Indonesia, or whether, for example, in New Zealand and Australia, majority of our conducts will not be detected by wajib or haram, those 2 which is part of law. They are either recommended or disliked or indifference. Now, in that area, Islamic law can still develop, or in many areas are very similar to other legal systems. So that's on law and religion. Islam has a divine origin. I don't need to explain to you. And then we come to, because I will be talking about Ummah, about Islamic states, let me explain Ummah and citizenship. Your Excellency, the Chair, I am like Fidel Castro and Muammar Gaddafi. When I get the microphone, I can keep going. Please let me know 5 minutes before my time is over. Then, unlike Muammar Gaddafi, I will finish. You remember that last year or the year before, he went to the United Nations and he had 15 minutes to talk. He talked 1 hour and a half. I don't. I will stop. Now, Ummah and citizenship. Now, I explained briefly Islamic law, Sharia, my interpretation. Everyone else obviously has the right to have different interpretation, and they have. That's my understanding. Now, when you come to concept of nation state, which I said it's a modern concept, no doubt about it that Islam definitely has contributed to the concept of international relations, international law, and concept of nation state. However, what has been articulated as modern nation states, as I referred, was developed in Europe. Obviously, that does not mean that Islam has not contributed. You may have heard names, important names, as Shaybani, Muhammad ibn al-Hasan al-Shaybani, a student of Imam Abu Hanifa, one of the 4 Imams of the Sunni schools of law. When I was studying in University of Tehran, I was studying law. I had a friend who was, a student there. Now he is vice president, or was vice president of Iran. Once in Islamic jurisprudence, I asked him why these 4 Imams of Sunni in different issues, I see always Imam Abu Hanifa's view is different with the other 3 or other 4. Why? He said because he is Iranian. Now, his student, Shaybani, developed the concepts in international relations and international law well before many other legal scholars, including Hugo Grotius from Netherlands or others. However, the Ummah, the concept of Ummah, which existed and still exists, under this international relations concept, Islamic international relations concept, and generally, I can prove this, under the nature of Sharia, Islamic law is bounds persons mainly. So its jurisdiction is about individuals, bounds a person. Doesn't matter whether the person live. It's in this territory, in another territory, who are the majority. This, of course, does not mean, as I mentioned, that Sharia does not have public law principles about international law and international relations. Now, because Sharia bounds individuals and applies to each individual Muslim, therefore Muslims who live anywhere now in modern nation states, they are bound by Sharia. Now, if you live, and that means that for purpose of rule of law or nation states or international law, there might be a problem here or an issue. And the issue is that Muslims who live anywhere, if they see that the system does not correspond to Sharia on their approach, they may not follow it. Whether they are in Muslim states, that many Muslim states, don't be offended, I don't say which one, have corrupt governments. Now, individuals don't feel bound by corrupt governments. One issue was raised here, and the chair admired it, about introduction of European codes into Islamic world after the after the collapse of Ottoman Empire. Since then, and after that, Muslims, even living in a Muslim country, see the legal system which applies there, for example, legal system of country A or B or C, they don't consider it as a legal system which is developed based on Sharia or based on will of majority of people. So they don't follow, or they may not have the conscience of abiding that system. Now, those Muslims, when migrate to non-Muslims, anywhere, I'll give you example of Australia, then they may have the same approach, for example, to Australian law, and that may cause some problems. Let me go through a few slides, and now I would be talking about Muslim minorities and citizenship, and that I'm now moving to modern nation states in the West, for example, Australia particularly, because I live there and I work there, and then Muslims who apply Sharia. Now, look, another term I have defined here is about a normal approach, uninformed approach. Have you heard about Muslims, Islamic law? There are different terms used: fundamentalists, Islamists, extremists. On the other hand, you've got moderate Muslims, rational Muslims, you've got modernity and things like this. I don't like to use any of those terms. I would like to use those two terms. This is absolutely my copyright. Okay. Normal approach. Normal approach. What is normal approach? When you live somewhere, it's that you live, you enjoy, you have, children, or you don't have children, you work, you pay tax, you enjoy your limited life, and you have some connections between you and some spiritual powers, whatever. That's very normal. And then I have used uninformed approach, and that's the approach that some people, and I'm talking about Muslims, have, and those Muslims are uneducated. Now, that's very, firstly, innovative, and it's not offensive, and you know that you have to change terms after a while because they become very negative. Very negative. But this one states the same thing. Normal approach, put in bracket, modern Muslims, rational Muslims, majority of Muslims, true Muslims. An uninformed approach taken to Islam or to Sharia, put in front of that whatever you like, depending where you come from. Now, I have an example to give about uninformed approach, and there is a verse of the Quran, and I explain things that how Islamic principles, rules, law is developed if you have uninformed approach or if you have a normal approach. Look, read this verse of the Quran, chapter 4, 140. These are the ones who wait and watch about you. If you do gain a victory from Allah, they say, were we not with you? But if he, unbelievers, gain a success, they say to them, did we not gain an advantage? Look, and the last part of this verse says, and never will Allah grant to unbelievers a way to triumph. That's, I got it from Yusuf translation, but then this square bracket, I put it there, a legal term. authority over the believers. If you want the Arabic translation of this verse of the Quran is, excuse me, those non-Arabic people, لَنْ يَجْعَلَ اللَّهَ الْمُؤْمِنِينَ عَلَى الْكَافِرِينَ سَبِيلًا. That means Allah will never give unbelievers authority over the believers. Now, this verse of the Quran is, as you can read from just don't take this part, get all of it. It was about a group of hypocrites, in which Arabic translation, munafiqeen, in state hypocrites, thank you, in Medina, where those people would go and tell to Muslims that we help you, give us booty of war. And when there were no victory for Muslims, like one of the wars, they would go to unbelievers. This verse of Quran says to them, look, these people, hypocrites, they go to Muslims, say something, to non-Muslims, say something less. Particularly, this verse came after the war of war of Uhud, where Muslims were defeated, and the uncle of the Prophet and many great Muslims were killed in that war. And this came that, and Allah is emphasizing that there is no authority from non-believers over believers. Now, how you can translate this, how you can interpret it, how you can approach it. Now, obviously, I won't do this. I think this verse of the Quran with other hadiths, with other verses of the Quran in context of Islamic jurisprudence and development should be interpreted, and people get different views. But one uninformed approach is taken by some Muslims, and that says Allah will not give authority over believers. Now, I would like to ask you something. You know, all of you, that under Islamic law, almost all Islamic law schools, traditionally, okay, a Muslim man can marry, according to Sunni schools, a Muslim man can marry a Christian woman, but a Muslim woman cannot marry a non-Muslim man. According to Shia Islam, is even stricter. Okay. Now, if you look at this principle in Islamic jurisprudence, go and see any schools of law, that part in Arabic. When they see that, they state the rationale for this rule, they refer to this part of the verse of the Quran. And never Allah grants to unbelievers authority over believers. Now, I don't want to go into more details of discussion of this, but look, out of this, that comes the, I have no problem by that traditional principle of Islamic law. And what I'm saying is recorded here. I'm not saying that the rule should be changed. That, not at all. What I would like to say is that the same principle has been used, and I have seen, by uninformed, uneducated approach that the law which is not Islamic has no authority over Muslims. Now, that as you can see, I don't need to go further and explain it, which is an approach which is uninformed. A normal approach or rational approach or modern approach doesn't say that. We can again cite from the Quran and from the Hadith and from jurisprudence and from development of Islamic law and from other examples and from modern examples that no, this was specifically for that purpose, and this does not mean that Muslims should isolate themselves from the legal system, which in the end they are who will lose if you live in a country and you create barriers in your access to the legal system. Okay. All right, this is more explanation of the normal approach, and now it's time for my conclusions. I made things easy for you, and I said that I don't have any conclusions. However, I can summarize what I've said. What I've said and what I meant to say here is that Sharia, which with all the definition that I said, covers all kind of possible conducts that you can imagine. 5 categories, and that applies to individual Muslims no matter where they live. Now, a normal approach, in my view, which I don't have time to explore, but I've written in my paper, does not create any problems and indeed contribute to conduct excuse me, of Muslims wherever they live. And therefore, Sharia may be practiced, and it is practiced in every corner of the world by Muslims, at least in part. Now, obviously, if you take a uninformed approach, I won't say traditional approach, I say uninformed approach, then it may create some tensions with modern legal systems, modern nation states, wherever they are.